application and prayed that the application will be dismissed. Submissions. Counsel Asimwe for the applicant submitted that the application is brought under Article 23(6) of the Constitution, which gives the accused person a right to apply for bail pending hearing of the case. That the offences with which the accused is charged are bailable by this court. He further made reference to the case of Dr. Kiza Besije versus Attorney General, Constitutional Reference Number 6 of 2005, which laid down the guidelines for consideration of bail. According to counsel, court needs to be satisfied that the accused will not abscond and will always appear whenever he is required. That all the applicant needs to prove is that he has a permanent place of abode within the jurisdiction of court, and that he has substantial sureties who will ensure that the applicant will appear in court whenever required. Counsel went ahead and presented the following sureties. The first surety was Mr. Chibazo Nasa, a 35-year-old resident of Kelezia Zone, Warigalo Parish in Mashdia Division, an advocate of the High Court, and a friend to the applicant. The second surety was Ms. Sevaduka Rukayat, a 56-year-old resident of Kawafu Sale, Katavi Town Council, Kawale Ward in Wakiso District, a biological sister to the applicant and a businesswoman. The third was Malay Ismail Seriko, a 32-year-old resident of Ketif Palau, Urban Council 1, Kawempe 1 Ward, Kawempe Municipality, a biological brother of the applicant and an accountant practicing with personal investments. And the fourth was Mbazira Koas, a 47-year-old resident of Kizito Village, LC1, Najana Kombi 2 in Ruaga Division, a long-time friend of the applicant and a poultry farmer. Counsel Asimwe submitted that he had explained to the sureties their roles pertaining to the application and they had understood. He prayed that sureties be found substantial and bail be granted to the applicant. Counsel sent to Mboyasin also prayed that bail be granted to the applicant on lenient terms and that court should not require the applicant to deposit a passport in court since he is not a passport holder. In response to the application, the Chief State Attorney, Mr. Biribuka Richard, objected to the application on the following grounds. A, as to the place, identity, and antecedents of the applicant. It was the state's submission that the applicant has no known residence, and it is not true that the applicant has a fixed place of abode. That even the true identity of the applicant was not disclosed in the application. The Chief State Attorney made reference to Constitutional Bail Guidelines of 2022, particularly paragraph 12A, which requires the applicant to furnish a copy of his national identity card or a passport or any sort of identification. He submitted that the applicant did not furnish a copy of his national identity card, and therefore his residence and identity both remain uncertain. Further, prosecution submitted that the applicant is an ex-convict who served 18 months in prison after being found in contempt of a court order, and that the applicant is known for being disrespectful, especially to judicial officers. On the sureties, I'll start with Chibazo Nasa. Prosecution objected to Mr. Chibazo Nasa as a surety for the applicant because he appeared in this very matter during plea taking as counsel for the applicant. He stated that he is unprofessional, uncourteous, and disrespectful to court for an advocate who appeared as counsel to now go and dress himself as a surety for his client. That the advocate is conflicted and therefore unsubstantial. Further, he submitted that this surety never identified himself as the national identity card that he submitted in court expired in 2024. The second surety that was objected to was Sevaduka Rukayat, and prosecution submitted that her introduction letter indicates that she's a resident of Wakiso, which is out of the jurisdiction of this court. Additionally, that the letter introducing Mabiriizi does not indicate anywhere that she has a permanent place of abode, and that her claim to being a businesswoman dealing in fishing gear is not backed by any evidence. For instance, a certificate of registration or trade name. That her identity is also in question as her national identity card expired. We can tender in court an introduction letter from the LC1 of Chiwongo, Urban Council 1, Mulago 2 Ward, and a NIN, which is a unique identifier for all citizens of Uganda as per section 68 and 69 of the Registration of Persons Act. That paragraph 12 of the Constitutional Bail Guidelines merely requires the applicant to produce a letter of introduction to prove his identity. On expiry of surety's national identity cards, Council Sentumbwe submitted that sections 5, 68 and 69 of the Registration of Persons Act are to the effect that expiry of a national identity card does not imply expiry of one's citizenship. He therefore opined that the surety's identity cards, even when expired, were valid in as far as the sureties are still considered citizens of Uganda. For the first surety, Council Sentumbwe rejoined that Mr. Shibazo, much as his partner in Shibazo and Company Associates, is independent of the law firm, and that he withdrew from representing the applicant, thereby choosing to stand surety for the applicant. In respect to the objection of sureties not having a fixed place of abode, he submitted that the state has not produced any evidence to prove that sureties do not stay permanently in the places that they submitted to court, and therefore court should not rely on those baseless assertions. Council Kamuka Maubadia also rejoined for the applicant on the expiry of the surety's national IDs, that the validity of the national ID is not listed as a statutory prerequisite for one to stand as a surety. That it is judicial notice that NIRA, that's the National Information and Registration Authority, has first significant administrative constraints in the mass renewal and issuance of national IDs, and as such, and that most national IDs issued by NIRA expired. Therefore submitted that it was incumbent on the prosecution to verify whether or not the sureties are the holders of the national IDs presented to court, and that if it was to the contrary, prosecution should present such evidence. The applicant also personally rejoined and submitted on the expiry of national IDs and quoted statutory instrument number 67 of 2024, titled the Registration of Persons Amendment Regulations of 2024. He quoted Regulation 3, which extended validity of the national IDs. He submitted that national IDs are valid by virtue of this instrument, that national IDs are valid by virtue of this statutory instrument. He also submitted that he is not an ex-convict as alleged by the state, and that the matter for which he served 18 months in prison is on appeal and therefore sub judice. In further rejoinder to the objection of not tendering his national ID in court, he submitted that bail applications in magistrates' courts are oral because they are basic and as such have no formalities required, like it is with the specialized courts, such as the Anti-Corruption Division. In respect to the sureties coming from places outside jurisdiction of this court, he submitted that the charge sheet upon which he is charged is from KMP, and all sureties are represented in court hail from the KMP region, a place within which the KMP police has jurisdiction to operate. It was therefore his opinion that the sureties are from within the jurisdiction of KMP, and therefore court should be able to reach out to them. I have considered the application, submissions of counsel for the applicant, the prosecution, and the applicant himself, and I find as follows. The Court of Appeal in Yang Zhengjun versus Uganda, CS application number 99 of 2013, stated that the right to bail has its foundation in the right to liberty, which is a universal human right and freedom inherent in every human being and is not granted by the state. Article 20, Clause 2 of the Constitution of the Republic of Uganda makes it obligatory for all organs and agencies of government, as well as for all persons, to respect, uphold, and promote this right, among other rights. The granting of bail by a court to an applicant is essentially an act of exercise of court's discretionary powers. The court, in considering a bail application, considers all that is before it regarding the application and reaches a decision based on the rules of reason, justice, and law. Judicial discretion that is exercised in this case is not private opinion, humor, arbitrariness, capriciousness, or vague and forceful consideration. To guide the bail application process, the Magistrates Courts Act provides factors that court must consider in deciding whether to grant or deny the application. Particularly in section 77 of the Magistrates Courts Act, considerations for bail are laid down, and among those are that when an application for bail is made, the court shall have regard to the following matters in deciding whether bail should be granted or refused. The first is the nature of the accusation. The second is the gravity of the offense charged and the severity of the punishment which conviction might entail. The third is the antecedents of the applicant so far as they are known. The fourth is whether the applicant has a fixed place of abode within the area of court's jurisdiction. And the fifth is whether the applicant is likely to interfere with any of the witnesses for the prosecution or any of the evidence to be tendered in support of the charge. The Constitutional Bail Guidelines for Courts of Judicature Practice Directions of 2022 further expound on the bail application process. Particularly, paragraph 12 sets out the contents of a bail application, while paragraph 13 provides for the considerations of bail. In consideration of the law relating to bail applications as laid above, the nature of a bail application is hinged on two limbs which an application should purpose to firmly establish. The first limb is the stability of the sureties, and the second, but most important, is the applicant's credibility arising from his own presentation of the application to prima facie position himself as a person who qualifies for the consideration of bail. I call the second more crucial because on the strength of the applicant alone, court can decide to grant bail on his own recognizance. Be that as it may, I shall consider the stability of the sureties presented before court before I move to the credibility of the applicant. The general objections to the sureties related to the submission of expired national identity cards, the lack of a fixed place of abode, and lack of proof of employment for financial gain. I will handle the objections collectively before making a finding on each surety. On the issue of expired national identity cards, it is true that the registration of Persons Amendment Regulations number 67 of 2024 that was referred to by the applicant extended the validity of all national identity cards. It extended the validity of national identity cards for a period of 1 year, which made the initial validity of the national IDs that were issued moved from 10 years to 11 years. In addition, Regulation 23 of the Registration of Persons Regulations requires that holders of a national identity card, a holder of a national identity card should apply to NIRA for renewal of the identity card at least 2 months before the expiry of their card. In this case, Sebaduka Rukayati's identity card expired on 5th December 2024, and an additional year puts this at 5th December 2025. Bazira Kowasi's ID expired on 6th September 2024, and an additional year puts this expiry at 6th September 2025. Ismail Sereko's national ID expired on 12th September 2024. A year added to this date puts this expiry date. Ismail Sereko's expiry was 12th September 2024, and a year added puts it at 12th September 2025. And Chivazo Nasser's ID expired on 5th December 2024, and an additional year puts the expiry of his identity card at 5th December 2025. As per the requirement of the law to apply for renewal, I presume that these sureties have already applied for renewal of their national IDs, because I'm aware of that there was a government program for mass renewal of national IDs, and every citizen is required to have applied if their ID expired. Since none of the sureties availed either a renewed or valid national identity card or proof of application for renewal of the said identity card, I cannot rely on these expired identity cards that were submitted. And on this ground alone, I find that the sureties have not identified themselves properly before this court and are therefore not substantial. Now, because the applicant can, on his own recognizance, be admitted to bail, I shall go ahead to consider the application in respect of the credibility of the applicant. The applicant presented his application orally and submitted a letter of introduction from the LC1 of Chiwovu Urban Council 1. His name was also read in court, and it was submitted that he is a public human rights defender. It is to this that the prosecution objected on grounds that it violated paragraph 12A of the Constitutional Bail Guidelines, which requires a copy of the applicant's national ID to be submitted. Counsel Sentumbwe, on the other hand, opined that paragraph 12 of the guidelines only requires a letter of introduction from one's LC to support the application. Paragraph 12A of the Constitutional Bail Guidelines provides that an application for bail shall contain the particulars of the applicant, accompanied by a copy of the applicant's national identity card or passport, or alien's identification card or employment card. The provision herein uses the word shall, and as such is couched in mandatory terms. It is therefore a mandatory requirement that an applicant for bail shall tender a form of identification to court in support of his application. It was submitted for the applicant that he availed a name to court, and the prosecution ought to have verified from NIRA if the name was valid or not. With due respect, I do not agree with this assertion. If the law had thought that a name was sufficient in supporting an application for bail, it would have said so, but it did not. A name can therefore not serve the same purpose as a copy of an identification card in this case. Looking at the applicant's application, there is no identification document of any kind tendered in support of the application. I therefore find that the application is lacking in terms of content relating to a copy of the applicant's identification document as required by paragraph 12 of the Constitutional Bail Guidelines. In the premises, therefore, I hereby dismiss the application for non-compliance with paragraph 12A of the bail guidelines. I so order.
Our inquiries are moving on very well. And they are soon getting completed. We seek to have this matter done with a view that we will have done some disclosure to defense, to have this matter heard the next time when it appears in court. So we seek an adjournment for further mention stroke here. We so pray.
Your Honor, I first object to our colleague's prayer for adjournment, and I have two very important prayers to make. And those prayers, Your Honor, are to the effect that this court shall hearing this matter. Not be required to come back to this court. Your Honor, my land before me has a third prayer which you will make yourself. I'll make this two and then you make the third. Yes, Your Honor. The first one, I wish to bring attention to this court that the Uganda Law Society filed a constitutional petition number 42, 2022, which is currently pending for the Constitutional Court. Constitutional petition number 42 of 2022. Which is currently pending before the Constitutional Court. Your Honor, this petition, among others, challenges the constitutionality of sections 26 and section 28 of the Computer Misuse Amendment Act. Which sections, Your Honor, are the same sections Mr. Mabiriizi is being charged under on both the counts. Your Honor, the basis for the petition, specific for section 26, is the fact that the section that relates to hate speech contravenes Article 28 of the Constitution, Article 29,
Article
28,
29,
Article 29, freedom of expression, and 43, which is the fundamental limitation of fundamental human rights and freedoms, as well as 44C, 28, 29, 43, 44C, 45, 79(1), that speaks to good governance, order, peace, and government, as well as Article 92. Talks about prospective legislation, matters that have been determined by the court. You're on Section 28, which is in the other two counts, relating to malicious information, which is also charged with contravenes. So Article 28, 29, 42, 43, 44C, 45, 79(1), and 92. Your Honor, that the Constitutional Court definitely declare this provision unconstitutional following the previous rulings we've seen. But Your Honor,
Will declare these provisions
unconstitutional. Considering the previous decisions of courts we've seen. Your Honor, there are two angles to this, and this will speak to my brain. Number one, continuing with such is in total breach of the sub judice rule. Because Your Honor, that means this court here, whatever evidence the prosecution intends to bring across, will be discussing matters that are pending in the Constitutional Court, which is the most superior court than this one. Defends that rule and should not be allowed. But Your Honor, my other specific prayer is that pray for the stay of these proceedings in this court, pending the outcome of the constitutional petition. Your Honor, in cases like this, while supporting a prayer, this prayer for stay, all one has to demonstrate, which we shall demonstrate. Because we know it's a demonstration of God, but the demonstration is that, well, we must demonstrate exceptional circumstances. Potential irreparable harm.
the exceptional circumstances?
Yes, potential irreparable harm. And a likelihood of success in the constitutional question. Your Honor, potential irreparable harm definitely doesn't speak the accused person who was paid 31 days. Probably, we don't know how long it will take, but considering the provisions under which is being tried, be declared unconstitutional, like provisions have been before, you can never recover that time. You can never be atoned to, not even by an award of damage, not compensation because the government never compensates people for some time. The psychological nature and the impact to have on this work. And the general public, again, that's potential to require more. Second, Your Honor, the likelihood of success of the constitutional question. Like I've stated, the constitutional provisions, this law in itself contravenes. Your Honor, it is equally in violation of international human rights treaties, which Uganda is signatory to. International human rights treaties.
And exception seconds.
The likelihood of success on constitutional question.
I think that is submitting more.
Yes. And Your Honor, section 26 and 8, the computer misuse amendment act contravenes or is inconsistent. They are inconsistent with Uganda's obligations under the Universal Declaration of Human Rights, specifically Article 18, Universal Declaration of Human Rights. Yeah. Specifically under Article 18, which provides for freedom of thought, conscience, religion. Article 19, freedom of opinion. Your Honor, I talked about 19, freedom of opinion and expression. 20, freedom from retrospective legislation, as well as Article 29.2 talks about limitation of fundamental rights. Your Honor, these same sections also inconsistent with Uganda's obligation under the African Charter of Human and People's Rights. Specifically, Article 7, the African Charter of Human and People's Rights. Specifically, Article 7, which provides for right to a fair hearing. Article 8, freedom of conscience. Article 12.2 provides for limitation of fundamental rights. Thirdly, the same sections, these are sections among others that have specifically 26 and 28, are also inconsistent with Uganda's obligations under the International Covenant, Civil and Political Rights, that is the ICCPR. Specifically, Articles 18, the International Covenant on Civil and Political Rights, ICCPR. Specifically, Articles 18, freedom of thought, conscience. 19, freedom of opinion and expression. And 22, freedom of association, as well as Article 12.2, limitations of fundamental rights. Your Honor, I complete that prayer, then I allow my clients to raise
I just want to interject for guidance.
To guide your counsel?
No, for to guidance. With me here, I have an application, which is rescue approachment. I have an application for lack of conviction. I have an application for reference to constitutional court. There is an application which is making a step of proceedings on account of pending constitutional petition. So I think we need to be guided which one should come first. Ordinarily, the refusal comes first because the integrity of the person determined these others has to be first cleared.
I think Mr. Mabiriizi should have a legal team. So you sit and agree on which way you want to go and put your presentation. Decide on which way you want to go.
Give us some.
How many minutes?
Also, whereas we have no problem.
Hold that.
No, not with the decision. Yes, what I say.
My mother, not my mother. She taught me manners. When I went to DC, it was very busy and the procedures. So, Your Worship, much I appreciate their right to make an application for the standover. For chronology of events, it would be much better if Council Asimu Anthony is allowed to finish his application so that we are on the same page.
He seems to be in a heated argument this time. And that's why he was not concentrating. So I don't know whether the client is withdrawing instructions on this application.
It's an issue of which one comes first because they have three like I mentioned. But there's one to so it's an issue. That's why I was saying guidance should we begin with this or because he has mentioned all of them.
But you see, logically, it depends on what you want again. If it is the recusal that you want, if among the applications is an application for recusal, so who is going to determine this one? It's what I'm wondering. So if among them is the application for recusal,
If we seek an adjournment in this matter, the defense can really reorganize themselves.
No.
And then we have it, a week or two is enough for them. Yes, 1 week or two is enough for the accused person to reorganize himself with his defense, make up his mind. Otherwise, this is a sense of disorganization and we are being taken up actually in this kind of scenario. We have other things to do. The defense cannot get organized well in court. They are supposed to have met prior and agreed on what to do in court.
Okay.
We have the ruling. Because the basis of this, the ruling in the bail application is the basis of these further submissions we are making. So if the state requires us to have prepared prior, it is seemingly impossible.
No, it's okay. I am the accused person. I hire advocates. I also So what I'm saying, I'm here to proceed. I'm here to proceed. I'm not firing them. I'm instructing them on the topic. My instructions are make a legal I mean, in choose application, I lay down the facts and which I can do, the supplement on the law, then we shall guide whether we can make other applications or wait for the ruling on that choose application.
I now understand what you want. Let me just put you on record before we proceed. So, if you're making an application for recusal, I'll guide that you put it in writing, upload, and the other
Your Worship.
shall proceed
Your
from
Worship.
there. I know that the application can either be oral or in writing. And I am guiding that you make the application
Last time,
in writing.
that's what you said. I've been at Maxwell for 31 minutes. Maxwell Bay has no computer lab. Has no computer lab where someone can sit down. Maxwell Bay has no internet.
Mr. Mabiriizi, the back and forth will not take us far.
Further instructions, procedures.
I know that the applicant,
Procedures are
Asimwe and counsel and the accused person, I have on record that the applicant wants to make an application for recusal.
I'm changing.
I have guided that the applicant, can you please sit down? I have guided that the applicant makes the application for recusal in writing. All right?
Because you don't have such powers, you want. You know, says, what are they going to be writing? So I was telling you from day one. You can never be in process.
So the matter is adjourned to 20th March.
For what?
They want we seek guidance when we come, not of coming back for what?
If you cannot judge us, retire, resign. What's the outrage? You have to put in restless. How do you reach better application?
What are we coming back?